Good morning, Judge Carelse.
That's it, okay. Morning, Chief Justice.
Are you well?
I'm well, thank you.
Thank you. I'm going to take you through very briefly and then hand over to President Maya. For how many years have you been a judge of the High Court?
12 years, Chief Justice.
And for how long did you act as Deputy Judge President?
For about 6 months.
And what about your acting stint at the Supreme Court of Appeal? How long has it been for?
This is my fourth term that I'm now currently in. My fourth stint, yeah.
Tell us about your experience and how all that has prepared you for the SCA and why it is necessary for you to go to the SCA. Okay. Just briefly, but without leaving anything of importance out.
Thank you, CJ. CJ, I was appointed, my legal career started off as a prosecutor. I was appointed in 1994. I prosecuted for about 4 years, and then I was appointed as a magistrate in 1998 for about 5 years or 6 years. And then in 2008, I was appointed as an acting judge. And 2009, I was appointed as a judge. And then in October 2018 to March 2019, I was appointed as an acting judge of the Supreme Court of Appeal. And then in June 2020 to November 2020, I was appointed acting Deputy Judge President, and currently I'm acting in the Supreme Court of Appeal. My work, as a prosecutor, I did criminal work. I also was a control prosecutor. I prosecuted in the regional court. My experience really was in sexual offences courts. I had to set up the sexual offences court when I was appointed as a regional court magistrate in Tembisa. My period as a magistrate, I served in Mitchell's Plain, and then from there I was in Johannesburg. And from Johannesburg, I remained in Johannesburg and got appointed as a regional court magistrate in Tembisa. Thereafter, I was appointed to the High Court, and I also did I also act in the Land Claims Court. I've been doing that for the past 10 years. From time to time, I go and act in the Land Claims Court under the the acting Judge President Mir.
And in a nutshell, why do you believe you should be one of the 5 to be recommended for appointment to the SCA?
Yes, thank you, CJ. CJ, I have my own experience. I've traveled, I've come from the lower courts. I've acted, I have faced the coalface of justice. I've worked in the lower courts. I've come all the way from that path. That's my career path. I've worked in the family courts. I've been exposed to almost every kind of matter that one can think of. I also helped set up the family court in Johannesburg. And I've got Land Claims Court. I've been acting judge in that Land Claims Court for 10 years. I'll bring that with me. I think I will be able to add value to the Supreme Court of Appeal because my experiences that I've managed to acquire over the years, and also where I come from, where I was raised, the community in which I come from, that experience, I think, will add value to the Supreme Court of Appeal. And just my wide range of exposure to matters. I've been fortunate, Johannesburg High Court, I think everybody knows the division and the work and the pressure that one works under. I can recall when I was first appointed to the Johannesburg High Court, I would receive 400 unopposed matters on a Friday afternoon, and I have to finish it by Monday, because on Monday afternoon I'd receive 20 to 25 opposed matters. And the variety, and without sounding like I know too much, the one thing I can say, when I got to Bloemfontein, the matters that came before me, I was fortunate enough that I dealt with the nature of the work that had come before me. I had seen it in Johannesburg. I sit in appeals, full court appeals and full bench appeals. So I also know, how to work with judges in appeals. And I'm also a senior judge. My experience as an ADJP was actually it opened up my eyes to the extent that, I saw judicial work from a different perspective and what's involved in allocations of matters. I also took the opportunity to expose women to matters that they weren't ordinarily exposed to. When I got to Johannesburg, and not under the time of the JP, the current JP, women just got family court matters. We got family matters with children. We didn't get all the very juicy matters, all the big matters. We were just relegated to second-class citizens. But that all changed. But I also, during that period, I made sure that I exposed judges to patent matters, to matters of huge commercial interests. And I think they were very grateful and thanked me for that, for exposing them to all of exposing them to matters that they ordinarily did not get in the past. I had a huge amount of support from the judges in Gauteng. They were very happy. And I want to say that I acquitted myself well. JP, I'm sure you'll confirm that.
Thank you, Judge Carelse. Before I call on President Maya to put a few questions to you, may I have a list of other colleagues who would want to put questions to Judge Carelse, please?
Lamola.
Lucas.
Dodovu.
Schlema.
Nyambi.
Tepe.
Matonsela.
Please, after Prophets who? Nyambi, okay, Honorable Nyambi, and then Commissioner Tsepe, and then who comes after Commissioner Tsepe?
None other than Matonsela.
Okay, all right.
Honor.
Is that you, Honorable Breitenbach?
Yes, please, sir. Thank you.
And then after, there was a voice after you. I couldn't hear who it was.
It was me, CJ Mpofu.
Okay, the voice was heavier than yours, though.
It was me.
It was Commissioner Barnard, Chief Justice.
Okay. All right. Thank you. All right. Thank you, colleagues. President Maya, over to you.
I think you're on mute, President Maya.
You are muted, President Maya. Please unmute.
This technology takes I'm getting used to. Thanks, DJ. Good morning, Judge Carelse. Are you well?
Morning, thank you. I am President Maya, and yourself?
Are you comfortable? You seem a bit nervous.
I'm very nervous, yeah. Said my mouth was so dry, and I'm fasting, and I'm trying.
I can see. Just relax.
Thank you.
We don't bite.
Thank you.
We don't bite. And look at me.
Okay.
You have one friendly face in the room.
Yes, I was looking for you, and I couldn't find you.
Before I forget, you omitted to mention two special attributes that your appointment would mean for the SCA, which has very few women and keeps losing its women judges to the Concord, and has no colored woman at all after losing Justice Theron to the Constitutional Court. So your appointment would also address the racial and gender diversity aspect.
Yes, thank you, Judge Maya.
Now, to my questions, in your 3 terms at the SCA, you have certainly a wide array of cases with all the presiding judges, I take it.
Yes, I did.
Now, you would have noticed that the SCA's judgment writing style is quite different from that of the High Court. The approach is incisive. I mean, you only deal with what's absolutely necessary and is concise. Our judgments are notorious for being short and written in as simple language as possible. Now, did you have any difficulties adjusting to this new approach, and how were your draft judgments received by colleagues in your panels?
Thank you, Judge Maya. I didn't have any difficulty. I think coming from a busy division, I always knew that you needed to deal with the issue at hand. So I always focused on what the issue was, and my judgment was written and reasoned once I've identified the issues. My judgments were received very well by colleagues. I've just written 2 judgments now, and one of the presiding judges was very happy with my judgment. The other one is still under discussion. And yeah, so I was encouraged by colleagues, and I also was of the view that you don't write long judgments. It's not necessary to deal with issues that are not an issue.
You wrote 2 judgments last term,
Yes.
and I note in the role that you will be writing in a big matter to be presided over by Justice Ponan,
Yes.
which will determine the meaning of certain provisions of the NEMA, the National Environmental Management Act.
Yes.
And you will also write in an important matter from the Land Claims Court, in which I preside,
Yes.
that concerns the eviction of farm occupiers, and that should be comfortable terrain for you. Now, would you agree that you have been given a chance to write judgments in complex matters?
Yes, indeed, Judge Maya. In my first acting stint, I wrote a judgment with Ponan as the presiding judge. It was a novel issue. It had to deal with Section 38 of the Companies Act, and I was the scribe in that matter. And yeah, I acquitted myself in that matter. I wrote for you. I wrote a land claims court matter, and we had about 3 conferences where I was trying to convince everyone about my views, but at the end of it, we all were unanimous, and that judgment dealt with an eviction as well, and I felt strongly about it. And the importance of that judgment was that the court had taken into account the social context when it decided the issue of residence. So and this term I'll be writing another land claims court matter which deals with breach of trust. I've come across those matters when I was at the LCC, so none of those issues are new to me. I am familiar with them.
Yeah, all right. You wrote a seminal judgment, well, I think it's seminal, in the High Court in the matter of State versus Kanye. And your judgment will likely result in an amendment of the law governing sentencing in gang rape cases.
That's right.
Can you just give us the essence of your reasoning in that judgment?
Well, the difficulty I had as a High Court judge is that because the stare decisis, there was a judgment from the Supreme Court of Appeal where 3 judges sat and decided that because one accused was only before the court, gang rape was not the appropriate charge, and then reduced the sentence from life to 10 years. I differed with that. I had strong views on the issue. The matter was given to me. I was in the full court. I was the scribe, I was the senior judge, and I decided to write this judgment. I researched this judgment because I couldn't sleep at night. It troubled me because the message out there was wrong as far as I was concerned, and I didn't know how to go about the judgment because it was difficult because the Supreme Court of Appeal had decided. In my research, I came across a judgment, State versus Lahoa, where 5 judges of the court decided the matter, not the same issue, but I took the legal point from the judgment, which was that once the jurisdictional factor has been met, then the minimum sentence legislation comes into play. And I then decided to rely on State versus Lahoa, and I said in that instance, I'm going to rely on that judgment. The jurisdictional fact had been established that this woman had been raped. She gave evidence by more than one person, and life imprisonment was appropriate. In fact, I must go on to say, and Chief Justice, you'll bear me out, I tried to get this judgment reported because once this judgment came out, JP will also be reminded that he sent me a letter congratulating me because he was getting a number of inquiries from the lower courts because the magistrates in the lower courts were conflicted. They had this problem because the difference between life and 10 is huge, because once you can't establish a gang rape, then the accused would get 10 years imprisonment. Anyway, I was concerned that this matter was not reported in the Green Book. I spoke to the researchers. We constantly wrote to them. And eventually, I think because this judgment, other courts were writing on this issue. Eventually, I think 3 years later, they reported it in the South African Criminal Law, but I had to ask them to do that. So that judgment, I think that was, the lower courts are very happy because now they can implement Section 51(1) as long as the jurisdictional fact has been established during the evidence.
And I take it there has been no appeal against
No,
it.
there's been no appeal, Judge Meyer. No appeal.
You are a founding member of the South African chapter of the International Association of Women Judges, and they have written a glowing report on your contribution to its objectives, especially the upliftment and enhancement of women in the judiciary and everywhere, actually, and raising awareness on the rights of vulnerable groups in society, including your membership in your community feeding scheme. Now, can you tell us a little bit about that organization and what benefits, if any, you've gained from your involvement in it? The SACA IWJ, that is.
Thank you, Judge Meyer. Judge Meyer, yes, I was the founding member. I sat on the interim committee with Justice Mohoro many, many years ago to try and establish this organization. We were very successful. There was a lot of hard work. We got a lot of support from the gender unit in the Department of Justice. And we were able to get the IWJ off the ground. And it's been an organization that's has profiled women. It is supported. I mean, one of the programs that I feel very passionate about is mentoring, is because I think that one has to give back. So one of the key programs that the IWJ runs is the mentoring program. I have mentored and I continue to mentor judges and magistrates in the lower court, judges in the high court, even senior counsel. When they have matters, especially criminal matters, they'll come to me and ask me for guidance or for my inputs in the matter. The IWJ, we're a chapter of the main body, and you are the president, Justice Meyer. We have been involved in many programs, and essentially what we do is we show our faces to the community. We put ourselves there. And may I say it this way, we adopt young students, we mentor them, and we even have awards at the end of when we have our annual general meetings to acknowledge these young girls and inspire them so that they know it's quite possible. In my community, when I was growing up, I was probably the first so-called colored girl that managed to get to university. I was always identified at university as the girl with the brown hair because I stood out at university. People, I was different. So I've always been involved in issues around women, gender issues. When colleagues didn't want to sit in the sexual offences court, it broke my heart, but it had to be done. And you have to have a certain kind of empathy to deal with children. And so that was I never shied away from any work. In fact, when people ask me, why did you apply to Tembisa? I said, to set up the sexual offences court. And, often the courts wouldn't run and wouldn't work. The TVs weren't working. We would run off to Kempton Park, but we got our work done. But anyway, I've never ever shied away from work. But I also, if I can recall, even before the IWJ was established, I worked with colleagues in trying to establish the guidelines for domestic violence. People complain that they get all these matters that seem trivial, children's matters, family matters, but I accept every matter, and it makes you a better judge. And I think having empathy is really an important quality of a good judge. And these matters are not important because maintenance matters, family matters are so important because, if kids are not taken care of, they're going to get into all the wrong things. If they're not provided for, they're going to join gangs. So all of those things concern me, and I never shied away from those matters. You will see one of my judgments, Justice Meyer, Nono Cynthia. I was a junior judge. It was a full bench matter where the issue was whether a grandparent who has a duty of care, the mother, as you know, in our South African context, with HIV that we faced and we still face this pandemic, children are now being cared for by their grandparents, and that's our South African reality. And of course, those grandparents are not wealthy. They don't have huge pension funds or trust funds to help them look after their grandchildren. So I looked at the matter and I decided that I was going to, I was described in the judgment, and my judgment at the end of the day said the following, that grandparents who are not financially capable of of supporting their children are entitled to foster care grant. And this mother or this grandmother was given a foster care grant for 3 of her orphan grandchildren. So that's the judgment that I penned. It was never taken appeal. In fact, it was welcomed by the Department of Social Work, to the extent that an amendment also came about, Section 150 of the Act. And based on that judgment, there was an amendment to the Act with foster care parents. And I get great comfort knowing, because, it's a very, judges, you've heard it from colleagues, it's a very lonely job. And, normally you're just pushing out the numbers, all the commercial matters, but it's very seldom that you have this feeling of satisfaction. And when you do things like that to change people's lives, to uplift people, to create a better country, a better community out of these children, it really helps. So I've gotten quite a bit of satisfaction out of those matters. And I also know that when I'm sitting in the urgent court, lots of the family matters do come, because they say I have a special way about myself, but in these matters, I treat every matter as a special matter, as important. I don't disregard any matter. Yeah.
All right, which takes me to my next question. You're also a Hague Network judge. Precisely what does that mean? What kind of work do you do? And have you written a judgment in that area?
Yes, thank you, Judge Meyer. So I'm one of the network judges for The Hague, and we deal with matters where children have been kidnapped by one parent. I represent Gauteng, I think Justice Ludwaba himself. So I'm the Hague Network judge. I haven't had a matter yet, Judge, but when I haven't had a matter to decide, but when I was the ADJP, I was confronted with this matter, and I had to ensure that this matter, I had conferences, I had the matter ready. And I think within a week, an allocation was done and the matter was heard. The father was in Canada and the mother had come to South Africa, and he wanted the return of the children. So I'm an active member I'm an active member, and also these things also, emanate from the IWJ.
Well, your life may be about to change, because these type of cases are few and far between. We don't get them all that often, but there is one that's likely to be coming. So we like to set it down, give it an expedited date at the end of term, so you may get a chance to write it.
Thank you,
but
Judge.
We'll see.
Thank you, Judge.
Lastly, Judge Carelse, there's raging talk in the country right now of a top 6 at the SCA. That is 10 of your colleagues, and everyone is asking me who these people are.
Yeah.
You are at the court now.
That's
now,
right.
First, you confirm that there are 10 presiding judges in the court. Oh,
That's
my
right.
goodness, my internet connection is unstable.
There are 10 presiding
confirm
judges.
for me.
Yeah, in this current term.
Yeah, it's Maya, that's me, Pete, Nafsa, Bonan, Wallis, Salduka, Mba, Zondi, Dambuza, and in Matopo's absence, Mochumi.
Yes.
Now, do you know if this top 6 is among these 10 judges I've mentioned? And if you know who they are, I mean, if you know them, who exactly are they? Can you identify them if you know them?
Well, of the 10, 9 are black judges. I know all of them, from Panan all the way, from Nafsa all the way down to Mochumi. I've worked with each and every one of them. In fact, similarly, in the previous term, it was the same. Out of the 10 judges that were presiding judges, 1 was white and the other 9 were black judges.
What experience have you had
Okay.
at their hand?
I was very fortunate, Justice Meyer, when I was invited by you, because most of the colleagues on the Supreme Court of Appeal bench, I've worked with them, or I've come into contact with them through the organization of the IWJ. But so most of the colleagues I was aware of. So I did receive a warm welcome, except of course I did have an unpleasant incident with a senior colleague, which I brought to your attention, and you told me that you would take remedial steps, and I'm told that you have done that. You also, I'm told, had a diversity training to discuss issues at the court, and colleagues who've attended it confronted some colleagues that they didn't think were very pleasant, and I got the impression that things were well. I'm back this term, and I can say categorically, without doubt, that the colleague and I have been very collegial. We've worked together in petitions as well as in appeals. And yeah, we've had debate, we've debated issues, and I think that the issue's been put to rest. I think you've told him that his behavior was unacceptable, and I think he's realized the same, because I've got a completely different reception this time round. So I thank you for that.
All right. Thank you very much, Judge.
Thank you,
Carelse.
Judge. Bye.
Thank you, CJ.
Thank you, President. Honorable Minister.
Yeah, thank you,
And
CJ.
sorry, maybe before the minister goes, President Maya, if for some reason I switch off my screen, you must know you are in charge, and
All
I'll
right.
take over when my screen is on.
I'll look out for that, CJ.
Thank you. Over to you, Honorable Minister.
Yes, Mr. Mamola.
Thank you, CJ. And good morning, Judge Carelse.
Yes, good morning.
Yeah, I only have two questions. And one is, there is a debate here you might be aware of in this commission about prosecutors acting as judges, or even you can even want to like to say as magistrates. I see you have got a lot of experience as a prosecutor. You have come through the ranks.
Okay.
How did it benefit you to interact with the Magistracy Act, or even in the bench, if you were able to? Or what is your view with regards to whether prosecutors should act or not act? Do you think there will be bias, or what kind of thinking do you have in that regard?
Okay.
And what do you think from your experience this
Okay.
House can?
So if I understand your question,
Yeah.
what you're saying to me is that, can a prosecutor who is still a prosecutor act as a magistrate? Is that the question?
Yeah.
Okay.
No, obviously they can act,
Yeah.
or they can act in the bench. The issue is whether they will be disposed to the state if they act
Absolutely not.
as a judge or as a magistrate. And that is what is being
Yeah.
debated here. So I just
Okay.
want to get from your experience, what is your
Yeah.
view about?
Look, I've got 27 years of experience from the time I started as a prosecutor until today. I prosecuted, and I think that experience really enabled me. I see things from a distance. I understand what goes on. I'm not impatient. I understand the difficulties of the thing, but it doesn't influence me at all. When I'm deciding a matter, the prosecutor must present the case, and I'm not influenced that because I come from that thing, I've got to have, sympathy towards that. I don't think I've ever been. There's any judgment where it's ever suggested that I've ever leaned towards the prosecution, or even, at all. I do think that if a prosecutor is still currently sitting as a prosecutor and then acts, it may cause some problems. I think, the bias, the perceptions that may arise. But I think that the route that I came up as a prosecutor, and then a magistrate, I actually know what happens on the ground. I've been there, seen it. I've faced the cold face of justice. I've dealt with people, and that's where people come to first. That's the first knock on the door. They don't see the rest of the people. You meet them in the corridors, you see them, and they come to you for help. And I think it builds you, it gives you an empathy and understanding, and you don't just, dismiss people. You treat people with dignity, and I think that made me understand it. And I've worked in areas where, for example, Mitchell's Plain, extremely poor area. People were very poor. Women would come in there desperate for access to justice, and you'd learn that you need to do more than what you're doing. You need to pick up their phone and phone legal aid. She doesn't have money. How on earth is she going to do that? In fact, I still have those habits. If people are in my court, they're destitute, and I can see that they're not going to cope. JP knows how passionate I feel about the legal aid. I call him up. I say, please come fetch this person from my chambers. I don't send them down and forget about them. Fetch them from my chambers and help them and report back to me. So I think all of those things where you just don't sit back like you're sitting in an ivory tower. You still edge towards, stepping more and assisting people as much as you can. And that's just the way I have. And that's what I think I picked up as, rolling boss, they say gathers no stone. I think I gathered a lot on my way up to the High Court.
So do you think prosecutors should be given an opportunity to act as magistrates or as judges. Do you think that would
Yes,
be
I think they
desirable?
should, but I think your difficulty is going to be is that while they're sitting in that position, still being a prosecutor and having to go back there. I think in my time, I was one of the first incumbents of the Bridget Mabandla aspirant judges, and there was that issue that arose. Some of the candidates, had to resign as prosecutors, and then they were invited to act because there was that difficulty. And of course, perception bias. You don't want people to apply for recusals.
Thank you, CJ.
Thank you, Honorable Minister. Honorable Lucas.
Thank you very much, CJ. Good morning, Justice Carelse.
Good morning.
I was listening to you very carefully, and I also read the one or two judgments that you spoke about. Last year, as Parliament, we had a process of engaging the country on the review of the Women's Charter, and there were some issues that was raised by the women, particularly the issue of lack of compassion from judicial officers or in courts and in as well as in police stations that they are experiencing, particularly survivors of gender-based violence and rape and so on. That's why I'm saying I was listening carefully, and I want to commend you on the posture that you have taken with regards to the way you are handling, or we see it in your judgment and also in what you have elaborated on this morning.
Lucas.
So I'm quite covered with regards to the issues that I wanted to ask you, but I still want to, in the light of what I've observed, want to ask you to respond to the question that will ask you, what is it that you think you will be bringing to the Supreme Court of Appeal?
Well, I think that my particular history, I come from all the way from the lower courts. That experience that I have, what I was exposed to, and coming from a division like Gauteng, such a busy division, the variety of work, and as I said previously, is that in all my stints up to date, it isn't a matter that I've seen that was unfamiliar to me. I'd seen those matters before: commercial matters, criminal matters, land claims court matters. In fact, this will be my second judgment that I'm writing for the Supreme Court of Appeal, a matter on land matters. So I think each person has a unique experience. We bring something different. No one is Zenat. No one has what I have. No one has had my experiences. No one's been exposed to my community. No one's been to my school. No one's had my parents, and what I was taught and how and the schools that I had gone to and my interactions throughout my life. And even, that particular experience from the lower courts, understanding what happens is, I think it's important. I think it's very important to know, where people come from. And when the judgment eventually gets to you, where it's been and the difficulties that are there. So I think that I have got that, I've got that. And also, I have got 10 years sitting in the land claims court. I not have a single judgment in the land claims court that was overturned. I was a judge for 3 or 4 years, and I penned a judgment, Florence versus the government of South Africa. In fact, in restitution matters, 2 judges normally sit. What happened, I was very junior. I'd just been appointed, and the senior judge, her mom passed on the morning of the hearing, and she had to go to the funeral, and I had to continue with the matter, and I did just that. I dealt with the matter. My judgment went on appeal to the Supreme Court of Appeal. I was confirmed in part and set aside in part, and then it went to the Constitutional Court. That's where it ended up very early. And of course, the Constitutional Court said I was right in both instances. And that was very early in my judgment, It's a family. In fact, that was very early. The case really dealt with the interpretation of Section 33 of the Restitution Act. And we all know that the Restitution Act is remedial legislation umbilically linked to the Constitution, which is Section 25 of the Constitution. And I had to interpret what was meant by change in the value of money over time. And it was a very, very long trial. Went on for about 1.5 to 2 years. And I had to decide that issue. But there was also very interesting, another issue that people don't really see was that I also had to decide whether or not I usurped the functions of the Heritage Council by ordering them to pay for things that they weren't even a party to. So that's what the Constitutional Court also confirmed. And I was set aside on that principle in the Supreme Court of Appeal. So I've done evictions, I've done both in the High Court, and I've done, your LCC matters, the restitution matters, labor tenants matters. I've done all of those matters. I've done Esther matters. I've just delivered a judgment in Esther not so long ago. Family, farm evictions in the Western Cape. So so I also bring that extra experience that I got along the way, along my journey. I take that, I will bring that experience to the land claims, to the Supreme Court of Appeal. And I must say that when I was asked to write these judgments, it was very comforting because I knew the area of law quite well. I'll never be an expert because I don't think we're ever going to know everything about the law. But even the matter that comes before me now, I'm comfortable dealing with the matter because I've dealt with so many matters, dealing with a breach of trust, insofar as the eviction of, if there's been a breach of trust, to terminate a person's residence as a grounds for the termination. So I have come across that. In fact, I'm writing a judgment. I've actually penned a judgment, which might be a dissent. It's not confirmed yet, also dealing with evictions. So I just, I sort of have that extra sort of experience and variety that I would bring with me to Bloemfontein if I was appointed.
Thank you very much, Justice.
Thank you, Ms. Lucas.
Chief Justice.
Thank you, Honorable Lucas. Honorable Dodovu.
Thank you very much, CJ. Good morning,
Yes, good
Justice.
Morning.
I'm happy that you are a judge in the Land Claims Court,
Thank you.
and my questions will be around that. One of the pillars of the current land reform policy of government is restitution.
Yes.
And linked to that, its underpinnings are willing buyer, willing seller principle. Why has it made it failed? Why has it failed? Because everybody is saying that, and what is it that you think needs to be done to improve the situation currently, notwithstanding that there is a process that is unfolding to explore the possibility of amending the Constitution?
The one thing that I don't want to forget, so I want to put it up front. I think one of the difficulties is and I think it's been mentioned here before, in these matters that come before us, you've got this imbalance. You have people who represent landowners, legal representatives who are far more experienced than counsel who represent the commission or government in these matters. And, if I can sum it up this way, maybe you'll understand. This is my philosophy, is that I think if everybody shared a piece of land that they had, I think we'd have less problems in this country. Now, restitution matters, I think people also don't understand that we don't get them until they're before us. There's a long process before it gets to us. It goes through the commission, the person has to, in fact, what happens in 1998, the closing date was the 31st of December, 1998. And then the claimant would have to have gone there, filled in the claim form, and go through the process. It would have to be investigated by the commission. And these things have taken years, 20, 30 years, unfortunately. But we only deal with the matter once there's a dispute. And it comes to the Land Claims Court. That's when we get involved. So the history before lands before us, it's out of the court's control. We have no control about it. And I think that's, the delays have also, those huge delays have also been a problem. I dealt with the matter where there was a willing buyer, willing seller. And, the valuers are people who come up with valuations. Of course, now there's a surveyor general and who does valuations. And there's always that contest with the amount, the compensation. So even at that stage, you will find that there'll be a dispute. So even if a farmer says, buy my land, I'm very happy to have it, he wants a huge amount of money for it. And then those matters come before us and we decide what is just and equitable. in those circumstances. So yeah, so those have been the things, but we are unable to deal with anything unless a dispute arises and it comes to the land claims court.
Yes, given what you explained
Yes.
as the process,
Yes.
that includes the land commission and so
Yes.
on, culminating into the land claims court if there is a dispute.
Mm.
Do you think, given the problems that you explained that they are encountered in the process,
Yes.
do you think that there is a compelling case to amend the constitution, or we can do with the current situation to an extent of ensuring that at the end of the day, sufficient land, well-located land, is transferred to the people?
I think, Commissioner, you mean Section 25, the amendment, the expropriation of land, okay? And I know it's received quite a bit of debate and there's ongoing discussions and consultations around this issue. Section 25(3) of the Constitution is clear, okay? It speaks about expropriation. And it speaks about nominal values. And if you're sitting as a court and you think it's just and equitable that the nominal value must be 0, so be it. So currently, as the Act stands, we don't have a difficulty, but those cases must be made out. We can't make out the case. So you come here and you say that the nominal value in this case, the just and equitable compensation in this matter is 0, because that's what it is. It's from 0 to any amount that you may determine that's just and equitable, after going through quite a long and elaborate exercise with all kinds of experts who all know better than everybody to try and convince you what the just and equitable amount should be. So that, I think, and then you also have the difficulty with, I think it's Section 12 of the Expropriation Act that deals with market value. Get rid of that. You've got an act, get rid of that, and we are empowered now to expropriate without compensation. If you look at Section 25(3) and I think 25(8) empowers the courts to do that now, but bring the cases to the land claims court. Bring those cases so that we can deal with them.
Just getting a point and clarity on that. CJ, sorry, I beg your indulgence.
All
Do you think
Yes.
that as Section 25 of the Constitution currently stands, that land can be expropriated without compensation,
Yes.
direct?
Yes.
Okay.
A firm yes.
Okay, thanks. Okay, fine. Thank you very much, CJ.
Thank you, Honorable Dodovu. Prof.
Thank you, CJ.
Yes, good
But
morning.
CJ,
morning,
Mr.
CJ,
Chairman.
Prof, with due respect, CJ, can I make a quick follow-up on that point? CJ?
Go ahead, Honorable Malema.
So now, I'm sorry, Judge. Since you have agreed that we can expropriate without any compensation, and it is very clear on the Section 25, subsection 3, do you think it will cause any harm to make it explicit in the Constitution, since it is now allowed?
Look, I don't think it'll cause any harm. If people are unclear about it, because no one's ever brought that kind of matter, unfortunately, to our court. So if people, that's why again, interpretation. That's my interpretation of that section. So if it's not going to cause any harm, look, the land claims court is under-resourced. It's undervalued. The work it does to right the wrongs of the past is such important work. It really has to be taken and put in its rightful place. That court must be treated. It must really be treated like your ordinary courts. It's almost like the adopted child. No one cares about that court. But it's such an important court. We are there to right the wrongs of the past. We're trying to fix things. So, Mr. Malema, yes, if that is what is required to right the wrongs of the past for more clarity, then I have no objection.
Maybe just a follow-up on that, CJ.
Sorry.
Or is that you, Honorable Moima?
Yes, Chief Justice.
Okay, sir. Please go ahead.
With the certification of,
Yes.
of our Constitution,
Mhm.
prior to, as part of its adoption, the Concord made it explicitly clear that any constitution that has to be adopted must abide with the 34 principles that were adopted by CODESA. And I take it that given that a principle that was adopted by the Concord, obviously with the amendment, there will be a process ultimately where the amendment will be taken to Concord. Do you anticipate any problem with regard to that?
Look, I'm sure people will be fighting it, and you'll have lots of, I'm sure you'll have lots of opposition to it. And I have to believe that the Constitutional Court will make the right decision. We've got able judges, and they'll decide the matter. You bring a good case to them, a very good case, and then they'll decide the matter. So I have no doubt in the ability of the Constitutional Court to decide this matter.
Thank you, Judge. Thank you, Chief Justice.
Thank you, Honorable Moeman. Prof.
Thank you, Chief Justice. Good morning, Judge.
Shlema.
I would like to ask you a couple of questions on your general experience in civil law specifically, because I see also that the JCB says in their comments that perhaps you don't have enough experience yet to be elevated to the SCA. What is your comment to that?
Okay. Thank you, Ms. Shlema. Yeah, it's quite an interesting comment that they make. The difficulty for us, and I've been there 12 years. I sit in very busy courts. I write judgments. It's my daily, for want of a better word, it's my daily bread. Now, as judges, I have absolutely no say what goes in that blue book, in the law reports. The law reports are controlled by JUTA. In fact, we have to pay for it. Am I right, JP? To have access to it. So I don't know what goes in there, but there are other platforms. I mean, if you just have to go into the various platforms, Safely, you go onto the land claim. I don't even think many people know that we have our own website, the LCC, on the judgments. And in the land claims court, our matters are civil. We deal with contracts, contractual disputes. We deal with settlement agreements. And I've done insolvency matters. It baffles me, actually, that they would have said that without justifying it. I've done civil matters. I've done reviews. In fact, one of the many reviews that I've done is the Arriva versus Westinghouse. That matter was a review, ISCM. It went to the Supreme Court of Appeal, and from the Supreme Court of Appeal, who set me aside on the merits, but upheld me on the point in limine. It went to Braamfontein. We were both told we were wrong, that the point in limine was good, but then there was a dissent who then said, we'll deal with the merits, and confirmed a puny judge in the High Court's judgment in respect of the merits. And they said that I was right, even though it's a minority. And who knows, maybe in 40 years' time, they'll rely on my minority decision.
Thank you for that. There's one big concern that I have, and I know lots of other academics and legal practitioners, and that is related to, and you might have heard it, I've asked it to quite a number of scholarliness, the depth. So you're quite well prepared. I would like to have your view on it. The fact specifically also decisions coming from the SCA that lacks the depth that we were used to.
President Meyer opened up by saying, I have a different approach to judgments. I think deal with the issue. If that determines the matter, that's it. You're writing for litigants. And I know you also the academics require. Scholarly judgments are meant for the use of academics. Am I correct, Professor Shlema?
No, it's meant for the training of the new lawyers because we're still
in an academic
system.
In an academic environment. I understand that. I always tell colleagues when they first got to the Gauteng division, they'd get 42 unopposed matters in a week, and maybe 1 or 2 opposed matters. So judges have a code of conduct. They have to work within those boundaries. They've got to deliver judgments within 3 months, all that pressure. And I don't think any judge is going to sit down and decide to write something that is not scholarly. I think that every judgment we produce is scholarly. We've thought it, we sit, we write, we think it, don't have the necessary resources. In fact, we pay for our own resources. And, we can pick up our hands and say there's nothing. We pay for our own internets at home. We pay for most of the things we do, we pay for, so that we can get the work done. So that's the context in which we currently work. So I have to disagree with you, Professor Shlema. I think that every judgment is scholarly. I want to believe that every colleague who writes puts their mind to it, reasons it out very well, and does the best that they could and can under the circumstances.
And at the SCA, which is the
Yes.
court that decides the matters mostly that are not constitutional?
Professor Schlemmer, I think that the SCA judgments are excellent. I think that the writing style, we've got a style guide. I think that the writing style is excellent. I think that, you pick up the judgment, it's 5 pages long, you get it. And I do understand your difficulty about training. Maybe you must invite us to train your students on judgments that we've written. If we haven't, expressed ourselves enough. But what happens is that we get all these papers before us, and we've got lots of papers in front of us, and we need to get to the issue. And once we get to the issue, the judgment is centered around that issue. So, I want to believe that the SCA's judgment is excellent.
Well, then one last point.
Yes.
Do you read the comments?
Well, Prof, you are going on to the 4th question now.
It's just the follow-up, sir. The follow-up.
Yes,
If
I
that would
thought
be
I
my
must
last
caution
one.
you. Go
Certainly,
ahead.
sir.
Yes.
Do you read the law journals where the judgment of the SCA and other courts are discussed by academics?
We expect that. We expect to be criticized. We expect academics to criticize us, and that's always going to be the way. There's always going to be criticism, but I think, sitting on the High Court bench and getting it from that perspective, it's very important to see it from our perspective. But you can go ahead and criticize us because there's nothing wrong with you criticizing us. But I say again, that those judgments, there's a lot of hard work in a very short time that has to be produced. I mean, the SCA, the rule of thumb in the SCA is that by the end of the term, when you leave, you'll hear the matter in the term. By the end of the term, that judgment must be out. And that's the pressure you work under. So the judges do their best. They write the best judgments that they can under the circumstances. And again, I think that they're all scholarly. Thank you, Professor. Yes.
CJ, is Julius here? Can I just make a quick follow-up? I'm sorry, I don't want to do this.
Sure, Honorable Malema, go ahead.
And I know I'm being unfair to Judge. Maybe she can help me. When they say the judgments don't have, do they have depth as they used to be then? I don't know. What is then? What's your understanding of then and now?
Well, then and now were long manuscripts.
Because then, for me, would be that
yes,
an impression is created that there was better judgments with depths during apartheid when the courts were white, and now that they are no longer white, there is lack of depth. So
Yes.
then and now, I don't understand. Maybe you can help me because this question kept on coming and I
Yeah.
don't understand it.
Look, I think you said it, I didn't, but let me end it like this. Let me end it by this and say the following. Corbett, there's judgment writing skills by Justice Corbett. And that's the mantra. He talks about this fancy language that you use. He speaks about, who are you writing for? I speak through my judgments. When my daughter was an attorney, reads my judgment, she mustn't come and say, explain this word to me. She must know what it means. So we write simply. We write for the litigants. We write for the law students. I can recall when I was at university, goodness gracious me, I had to have a book in front of me. I didn't figure out, it took me so long to read a judgment. It's much easier. When my daughter reads a judgment, she gets the issue immediately. And she gets it, So, I don't think, we're writing for the litigants. Language is a big barrier in this country, so we try and write as simply as we can. So, Mr. Malema, as I said, you said it, not me.
I hear you, Judge.
Chief Justice, a quick short follow-up. Singh here.
Mr. Singh.
Yes, Honorable Singh.
Yes, Chief Justice, I'm surprised to hear from the judge that the tools of trade are not provided to judges. And I don't know whether this applies across the board, but it's something that we've got to address because judges are doing a job for the country. And if they're not provided the adequate tools of trade, like data and things like that, then it becomes a bit of a problem. I don't know if you'd want to respond, or Chief Justice, you can take that up. And the Minister, thank you.
Well, no, I think it's an issue for a separate meeting.
Thank you, CJ.
Thank you. Honorable Nyambi.
Thank you. Morning, Judge. There's this old adage that in the absence of information, sometimes or many times perception becomes a reality. So I don't want to fall to that trap. I'm taking it from what was said when you're responding to the president. The issue of the unpleasant treatment at the SCA. If you can share with us so that we can have a sense, because we've heard some other stories.
Thank you, Commissioner. Commissioner, I was surprised when I went there because this issue arises every time at this forum. I was surprised. I think the colleague, in retrospect, must have been surprised by the quality of my work. I think he was surprised that I could write such a good judgment. And it was about a judgment that I wrote, and he had been told, and I give him the benefit that someone had whispered the wrong information in his ear. And, we had an unfortunate incident, and I must tell you very clearly that I told him it was unacceptable. But to rest your mind, at the end of it, the matter was determined in my favor. I delivered my judgment. That is the CDH matter versus Amububezi. And but what I want to repeat is that I'm confident that the president of that court has dealt with the matter, because I can safely say that my experience this time is a very different experience.
Chief Justice J.P. Mlambo here. I'm sorry to do this. This incident was also reported to me, and I would like the candidate to respond to the question. The Commissioner Nyambi wants the details of the unpleasantness.
Thank you.
I think that's the question. Because the Commission has had a lot of these things, and they want to know what happened.
Well, as I was saying, I wrote a judgment, and I presented it. And I'm just giving a very short version of it. I presented the matter in fact, now let me go step back. I wrote my judgment. It was the CDH versus Amububezi. And while I was busy with the judgment, a panelist came to me and asked me if he could see it. I said, of course, I'm very happy for you to look at it. One of the panelists, he had a look at it. And on Monday, when I got to the office, he comes to me and he says, I'll make a few little comments. I said, I'd be very grateful for that. And then later in the afternoon, I can recall I was sitting with a colleague. He comes to me and says, while I was doing this, the senior came in. Anyway, to cut a long story short, he had given the impression to the senior that he had altered my judgment to the extent that my judgment needed a second name on it. I was taken aback. I was completely thrown. In fact, I was insulted. So what I did was I decided, let me go to senior colleagues and say, look, if you think that the inputs made by the colleague justify a second name on this judgment, I'm very happy to do that. So I went to see a few senior colleagues and said, absolutely not. This is your judgment and stick to it. Put your name, and I did just that. The matter, in fact, was resolved by the conference. So, you should not be concerned about anyone trying to bully me or take advantage. I will deal with them. But all I'm saying to you is that this issue arises all the time. The president, that court is a very different court from 2018. To what I'm experiencing now. There's collegiality amongst colleagues. We debate freely. You can see, I think, in fact, just before I came, I think there was a complaint by the colleagues that they weren't given to write. Everybody writes. I, as an AJ, have written novel issues on law. Section 38 was a novel issue. I'm writing another matter and to say that the colleague and I were collegial, I'm actually writing for the colleague again. So, the one thing a judge thrives on is collegiality. You'll not survive being a judge if you don't have this collegial relationship. And yes, JP, you will bear me out. Even in Johannesburg, colleagues get under each other's skin. They get under each other's skin and they come to you and they report it to you and you deal with it. So I'm satisfied that the president, in fact, what she did was she called in the colleague and she sent her judges on diversity training to understand that, certain conduct is unacceptable. So, yeah, I hope that satisfies you, sir.
I hope also you understand it's not your personal matter.
No.
Because what was explained about the SCA, even the president, when she was interviewed for that position, she shared with us some stories. Her
experience, yes. But it's very different now, Mr. Nyambi. In the term that preceded me, out of the matters that I sat in, majority of them, we were women dominated. We were 4 women to 1 male presiding judge. So the dynamics, the demographics, the changes, people are retiring, they're going on, that court has been built up and people are putting from different experience bases. So that it's changing, and change doesn't happen overnight. Besides just changing, you also, it's attitudes that have to be changed. And again, diversity, social context, people be alive to other people's, cultures, and to understand how other people feel about issues. Sorry, and that's one of the things that the judiciary is now, they're going forward with that. I think there's been several, even Gauteng has had diversity training. JP, you'll understand. But I must say that in my experience, Judge Maya takes the bull by the horns. She calls in the colleague, she's unafraid, and she deals with it. And she's made the colleague understand that it is unacceptable. Make no mistake, if there's a repeat of that, I will report. I'll do the right thing. But I think I'm acting in that division at the moment, and I have been, I'm working with the colleague. In fact, many times I've sat in matters on appeals and in petitions, and I can say that the colleague and I are getting along quite well. So yeah, I hope that satisfies you.
My last
Mr.
question.
Nyambi. Yes.
If you can share with us your understanding of judicial independence.
Judicial independence, sometimes I think that people, the separation of powers, what one must understand is that while we say judicial independence, and I mean that when I sit on the bench, even if I'm sitting on a panel, I'm independent, it's my decision. No one can call me, no one can tell me what to do. Okay, so that's what I think is your judicial independence when you sit on that bench. But there's also an interdependent relationship between the various arms. We have three arms of government. We have the legislative, the executive, and the judiciary. And what we have to do is, because we need the support from the executive and the legislative for us to do our work. So we have this interdependent relationship between them. So sometimes people throw separation of powers in the air and you all think that you're in a box. We're not in a box. We're all part of one big process, one long chain where we all connect with each other. So, but when you're on the bench and you're deciding your matter, that's judicial independence in respect of decision making. But I'm the first person to accept that there's an interdependent relationship between the various arms of government.
Thanks, Judge Carelse. Thanks, CJ.
Thank you.
Thank you, Honorable Nyambi. Commissioner Tsepe.
Thank you, Chief Justice. Good morning, Judge.
Morning.
Judge, I just want to ask you two questions,
Yes.
and they come from they're related partly to the GCB's comments.
Yes.
And I want to hear your view on that. And I want to hear that. The SCA has a record over and above some of the issues raised by the president on delivering judgments promptly.
Yes.
Do you believe that this is a record you would be able to keep? And can you give us a sense of your own record in the High Court and in the SCA?
I've been a judge for 12 years. I've never been reported for a long outstanding judgment. That's the first thing. The second thing is that it's my third, I'm going to my fourth stint, and I was able to deliver judgments promptly at the SCA. Both my judgments, one was delivered this morning, and the other one I've got no control over. It's with the presiding judge in case there's a dissent. So yeah, by the end of the term, my judgments were ready to be delivered.
And that should be an indication to show that you are ready to go to the
Yes,
SCA.
of course. Thank you, Mr.
Judge, the second question relates to how the SCA sits. Mostly in the High Court, cases are heard and decided by a single judge.
Yes.
In the SCA, obviously, that is
Panel.
different. Do you believe that full bench appeals provide a reliable measure to test how a judge would cope in the SCA? And if so, can you please give us a sense of your experience in full bench and other appeals?
Okay. Well, full court, we sit as three judges, and that's a judgment of a judge that we hear. So, and that in Johannesburg, JP, you'll think, we're not like other divisions where full court appeals are done at the beginning of the term and only then. Full court appeals are done daily in our division. Twice or three times a week, JP. So and as a senior judge, you're put in those matters because you've got to have seniority. So I am a senior judge in that division, and I deal with full court appeals all the time. And and because of the volume, keep doing this, I beg your pardon, and because of the volume of the full court matters that we receive, because of the volume of the full court appeals. So yes, experience. I'm dealing with the daily. I'm across the board, civil, criminal matters. We deal with it. So I've seen over my 12 years a huge amount of civil, and absolutely, it's taught me how to look at a matter, how to work with colleagues, especially, you know, if you come from a division where you don't work with colleagues, it's also something that you have to get used to. So I didn't have to get used to that. I know how full courts work. I know, you know, how you look for the issues, how you deal with it, how you control your court. And as a senior, I'm the presider. And I know what the responsibilities are. So yes, that's really equipped me for the Supreme Court of Appeal. And not only that, we also do full bench, which are appeals from the magistrates' court. And that is we do hundreds of that. So yeah, and again, I think JP, you can bear me out. Full court appeals, within 2 weeks, our judgments are out. Full bench appeals, the next day they're out.
Thank you, Judge. Thank you, Chief Justice.
Thank you.
Thank you, Commissioner Tsepe. Commissioner Madonsela.
Thank you, Chief Justice. Judge Carelse.
Yes.
Good morning.
Good morning.
Good afternoon. For the record, before I pose my question, for the record, so that the world might know, you come from Durban, don't you?
Yes, I do.
Yes.
But before I got there, I was in the Eastern Cape because that's where I was born.
That was unnecessary.
Yeah.
Yes, I see that you have applied for the SCA and
Yes.
you have acted as a DJP
Yes.
in Gauteng. In the days to come, next week or this week, we will be interviewing candidates, and one of them is a position of a DJP for Gauteng. Is there a particular reason you didn't apply for that position?
Well, judges don't apply, Mr. Madonsela. You get invited, you get nominated. So I was nominated for this position.
Is there any particular reason you're not nominated for the other?
I don't know why. Look, let me say this.
I'm just sensing the sentiment.
Yeah.
Am I wrong about that? Good thing. I'm not saying it's the best.
Yeah, Mr. Madonsela, you know, I really enjoy writing judgments. And I know that in the High Court in Johannesburg, our DJPs, we also hear matters. And I think that I would be best suited with my experience and my history to add value to the jurisprudence of the Supreme Court of Appeal and to bring something different to the Supreme Court of Appeal. As I said before, my unique experiences must impact on my judgments. So I think I can add a lot more value in the Supreme Court of Appeal. Thank you.
Thanks. The second question is one that is probably more jurisprudential. You recited an incident where you...
CJ, excuse me, Mr. Madonsela. I'm struggling to hear Mr. Madonsela.
Oh, sorry.
Maybe he's far from the mic or speaking softly.
Oh, thank you. Can you hear me?
That's better.
Thank you, President. You told us about a judgment you wrote, and there was a judgment of the SCA.
That's right.
That was...
State versus Mshlasi.
Yes. Now, if you are in the SCA and you write you take a particular view on a matter.
Yes.
But we have an authority, higher authority, in this case from the CC, that is creating a problem for you to arrive at the conclusion that you wish to arrive, that your gut feeling says this must be the conclusion in this matter. But there is this constitutional court judgment that stands on the way. What do you regard as the role of the judge in the SCA in that situation to be faced with the judgment of the Constitutional Court?
You know, we are bound by these rules, stare decisis. And unfortunately, the Concord has decided a matter. Look, everything's fact-driven. If I believe that my facts do not fit into that kind of, it doesn't fit that particular matter, I will write a judgment with my facts and say why I do not think that matter is relevant to my matter. So everything is, things like that mostly are fact-driven. So you will look at your facts and you strongly believe that your facts differ from that, you'll write that judgment.
If it's not distinguishable and it's an all false,
you've got then it's difficult for you because it's of our stare decisis rule.
Or would you not be duty bound?
You are going on to the fourth question now.
Oh, sorry, Chief Justice. I just want to find out a follow-up question, just one, on the same topic.
Carry on.
Wouldn't you be duty bound to make a comment about your feelings about or your view about the position taken by the Constitutional Court on the issue, albeit bound by it?
You see, sometimes, Mr. Madansela, when you write judgments, you also can't be you've got to be careful how you write because you don't want it to look like there's a fight between the two courts. You need a stable judiciary, you need a stable jurisprudence. So if unfortunately I can't do anything about it, why? Yeah, I suppose in a way, you'd have to think about how you did it. You can raise, but it would have to be careful. The difficulty with me with Mashlaste, I really couldn't sleep with that matter. And it was 3 judges from the Supreme Court of Appeal. And I had to find a way around it. And then I researched. And if you work and you research, I then realized, but why can't you use another judgment from the Supreme Court of Appeal? They were completely different facts. And I went on the jurisdictional fact. Those were 5 judges. And that's how I got around State versus Mshlasi. Without upsetting the norm of stare decisis, I didn't. Hasn't been on appeal. And it's now going to be Justice Lamola, y'all are making an amendment, I'm told, will be coming through shortly, dealing specifically with Section 51(1) of the minimum sentence, in particular when it comes to gang rape. The anomaly of that judgment was that accused number 1, if he gets arrested first, he gets 10 years. Accused number 2, who comes alone, and he gets arrested after number 1, who's sitting in jail, he gets life. So, I had to do something about that.
Thank you, Chief Justice. My apologies for exceeding my time.
No, I understand, Senior Counsel. I really do. Honorable Breitenbach.
Thank you, Chief Justice. Good morning, Judge.
Good morning, Ms. Breitenbach.
I must say it's really nice to see a previous prosecutor doing so well done.
Thank you.
I have one question. You partially answered it. Your experience in the Land Claims Court.
Yes.
What can be done practically and in the short and medium term to make that court operate more efficiently and more effectively?
Thank you, Ms. Breitenbach. Ms. Breitenbach, I just think that more resources needs to be given to that court. It's under-resourced. And I'm not sure if it's changed, but I think there's only one regional commissioner. And she's got all this work on her hands. I'm not sure if it's changed, but I think more resources. I think very few judges will sit in those courts. But, one also has to understand restitution matters take very long. The evidence that is led is very long. So daily we deal with evictions, we deal with labor tenants matters, but your restitution matters do take a while. But I think that the court is terribly under-resourced and it needs more resources for it to do its work. If you just look at the statistics from that court, once a matter's there, we get done with the matter, we run with the matter. We also have a pre-trial conference. That court is a different creature. As a judge, you're very creative. You get your hands in the matter. So from the moment the matter is allocated to you, make sure that matter runs. So you put people on timelines, you give them directives, and similarly, JP, like in the Gauteng, the way pre-trial conferences are running there, that's how so the judge who deals with the matters dealing with all of that together with all the other stuff. And at any given time, I think there's no more than 4 judges, including the acting president, including the acting JP at the time. So there's no more than 4 judges at that court. But and JP Mlambo is the one JP in most provinces who allows his judges to go and act there. I think that Justice Meer, I've been there long enough that she struggles to get judges to go to that court.
Thank you very much.
Thank you.
Honorable,
A quick follow-up on the last question, CJ, with your indulgence.
Okay, Honorable Minister, go ahead, please.
Thank you, Judge. On the question you've just answered, on the court needing resources and so forth, you are for sure you're aware that we have just submitted a land court bill.
Yes.
Do you think, in terms of its architecture and also the intention of creating permanent judges, will
Excellent,
it resolve the problem?
It's going to help go a long way in resolving the issues. There's no permanency. Sometimes that court is run just with acting judges. It can't work. It's a problem.
Yeah,
So I'm clear that this new the land court bill, when after consultation, when it becomes acted, also have appeal status, similarly to that of the Supreme Court of Appeal. And very importantly, it also suggests mediation, which is a very, very important tool in that court. So I think the additions to the new land court bill, when it becomes law, it will be very, very helpful when those things come into play.
Thank you, CJ.
Okay.
Thank you, Minister. Commissioner Mpofu.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon,
Yes. CJ, I've largely been covered. I'll only ask one question. I was covered on the appointment of prosecutors. I was covered by Justice Lamola. and also on the issue of the fallacy of thinking that you can address the land question via litigation. I think you've covered that issue. And thank God you've also covered my issue. I've been wanting to ask this since yesterday, if there's such a thing as an unscholarly judgment. But now I think this has been put to bed, that all judgments are by definition scholarly. Now, the only issue I really want to raise with you is just a follow-up on Mr. Madonsela's point, and I want your comment of whether it's a fair or not fair comment. I've had the pleasure of dealing with you when you were acting DJP in Joburg, and sometimes I was not happy with some of your directives, but that's exactly what we're here for, not to be very happy. And my question is really this: would it be unfair to say that it would be a loss to the division for somebody like you to go to Bloemfontein? I know, look, the personal career prospects and choices, as you said, you prefer to write judgments and contribute to the jurisprudence. That's a fair answer. But seeing that we have, particularly in this, the busiest division in the country, where, if I may, the reason why that you are acting Deputy President is because you are in the top 6 of this division. And now, so for you to have to go to be in the bottom 5 in Bloemfontein, we will lose both the judgments, and you're sitting in serious matters and appeals, 3-judge appeals here and so on, but also your administrative capacity, which I think is quite it's a good combination to have, both the judicial capacity in the narrow sense, but also the administrative capacity. So in short, you would probably be one of the most senior Black women, using the term in the general sense, in this division, and obviously be lined up for a leadership position, even potentially speaking, rather than going to be a follower somewhere else. Is that a fair comment? Or should we just take it on the chin? I know it's a selfish position because it's based on the division. But what would you say?
I get your point, Mr. Mpofu. I do get your point. And I think someone raised it that should actually stay in the land claims court because of the judgments that I've written. But, I think that the way in which the division is managed now, I think there are lots of competent women who equally equip themselves, like I did when I was the ADJP. Women know how to manage, and that's a very good quality. And I think that the structures and the what's been put in place in Gauteng. I actually was the ADGP under very difficult circumstances. Under COVID, everything was virtual. And you had to manage colleagues who were, some of them were not very computer literate. But anyway, all of that aside, I believe that our division, because we are fortunate to be given opportunities. In other words, if I want to go to the Labour Appeal Court, I just have to say to my JP, I want to go there. If I want to go to the LCC, I say, can I go there? He says yes. So colleagues and junior colleagues in that division are put in charge of commercial court committees. So I strongly believe that we have enough women in that division. And if we're talking women, then it is enough women in that division who are very capable of doing what I did. So I think that my experience at the SCA, yes, I'll crawl before I walk, and one day I'll be senior, Mr. Mpofu.
Yes. No, thank you. So in other words, you're saying our loss would be somebody else's gain. Someone else would come up.
And open up the way for someone else.
Yes, that's what I'm saying. Yeah. Thank you, CJ.
Thank you.
Thank you, SC. Commissioner Barnard.
Thank you, CJ. Good morning, Judge Carelse.
Yes, good morning, Mr. Barnard.
I'd like to know, you while saying on the one hand, you say it's a lonely job, you also refer to collegiality, and then just now you spoke about judges equipping themselves. But I see that you've also been involved in training junior judges and aspirant judges, as well as done some advocacy training.
Yes.
So, one of the things of training is one obviously learns yourself. And so also to try and maybe just explain to the Commission your lessons learned from the training experience and how that has enhanced or enriched your ability to be a judge of the SCA.
Thank you, Mr. Barnard. I actually didn't speak about that. Yeah, Mr. Barnard, for as long as I know, I've always have been open to better myself. I've never turned down a cause that becomes available for judges, because I think the more you know, the better for you. I'm a firm believer that whatever you acquire, you must share. So mentoring, I think, is one of the most powerful tools where we can transfer our skills. You must remember when I got appointed 13 years in acting, but 12 years as a permanent judge. I was the first magistrate in Gauteng to be appointed, and I knew the task at hand, because if I failed, it meant that the perception would be that magistrates are not up to the job. So I knew the responsibility. So I did whatever I had to do to up my skills. And I also realized that, when you're teaching, you've got to prepare yourself. So at the same time, you're learning. So right from the magistracy, I've always been that person who has trained. I've even extended myself by training assessors so they get it, because Section 19(3) of the Magistrates Court Act, where assessors are required in matters concerning violence and in particular murder. So I've always trained. As a judge, I am currently one of the trainers for SAJA. I've just trained 2 weeks ago a number of aspirant judges. What is important about training is that when people then, you get the opportunity to debate, and you see where people struggle and how they see things and the angle that they see things. And what it does is that it helps you, especially also when you're writing judgment, because when you're dealing with the judgments, you see that they grapple with things and the understanding of certain issues. So mentoring, training, I think will always make you a better judge. In fact, I think in Canada, judges are required compulsory 19 days of training. I think that's what it is. So I don't think anyone's an induna of the law. And I think if you really want to be in this job, you got to learn every day. Keep yourself abreast. So in that way, Mr. Barnard, I think that it's made me a far better. You must remember, I've never been to a tax court in my life, but I penned a full court judgment that was confirmed by the Supreme Court of Appeal, BMW versus SARS. It was the first time I'd ever come across the SARS. But as you know, SARS is when they send you a little slip and say you owe the money. That's the first time you come to hear about them. but I was able to acquit myself in that matter. And again, as I say, in Johannesburg, you can't say I don't know that. You have to know everything, and if you don't, you have to learn on the job. You know, and nobody comes with all that experience. I've had senior counsel come to me and they grapple with criminal matters. You know, they struggle with it, and I think that I'm equipped to guide them. And, you know, in Joburg, it doesn't matter whether you're a senior counsel coming. If you struggle, you come. That's collegiality. You must be able to knock on your colleagues' door. I was told when I got to Joburg, even if I'm sitting in court, send your clock and leave a note, but don't make a fool of yourself. You know, so daily, you know, Johannesburg, our tea room, I also know that we sit and we discuss matters. That's why Going to Tea is such an important event in our High Court, because that's where colleagues are struggling. So, and you're engaging every day. It's the best job in the world. You are learning something every day that you didn't know yesterday. You know, so that's, and I think that's what drives us. That's what pushes us ahead, because we have sleepless nights. We, you know, you heard one of the judges, you know, going to bed at 2 o'clock in the morning, you know, that's the norm. But, so yes, Mr. Barnard, I don't think you can come to the bench and not think that you know everything. You must make yourself available make yourself available, and education, training, those are the most important things. The one valuable lesson I had from my father growing up when he had to put one child through university because he couldn't put the other two. He just said to my child, if you educate yourself, you'll liberate this family. And that's what happened. So it sticks with me. And my mother used to say, knowledge, you take it with you to the grave, because they can take your money, they can take your car, they can't take your knowledge. You'll take that with you to the grave. So yeah, that's my thing. I hope I answered you, Mr. Barnard. I got a bit carried away.
Thank you. Ample, Judge.
Thank you.
As far as you referred that, you know, one writes the judgments for litigants, and you mentioned that language is a barrier, but of course there's another barrier for litigants, and that's the costs. First of all, the Supreme Court of Appeal is situated far from many litigants, and the average member of the public can't afford to take a matter there. It's a question of you know, it's not just the representation, it's the cost of traveling, sometimes the cost of accommodation, and all sorts of other things. So what do you think can be done to make access to justice to the broader public, to the SCA specifically, more of a reality, and specifically talk about maybe digitization and lessons learned from the lockdown processes you made a short reference to?
Well, I think maybe, Judge, before you answer, the question I wanted to ask but wasn't going to ask because of time constraints, don't you think that to make justice accessible, we should cut down on the many appeal stages in our court system?
Sorry, I lost you, but the CJ, cut down on? I didn't get you.
The many appeal stages. You appeal to the High Court, you appeal to the SCA, you appeal to the Constitutional Court. Shouldn't we find a way to cut down on those many levels of appeal so that justice could be more accessible to the people?
Absolutely, CJ. I think that maybe the Supreme Court of Appeal and the Concord maybe should become one court, and that should be the final arbiter, one appeal court. I know this debate rages and people talk about it, and it's controversial, but yeah, I think at the end of the day, we constitutionally bound to make sure that people have access to justice. And yes, the politicians must decide the way forward. I mean, this issue has been mooted and been discussed many times out there in the public. So I agree with you, CJ, that the process must really be streamlined. It's just, it takes too long, and the cost involved is just enormous for litigants. You know, once you're you can get an appeal to the full court. From there, you've got to then petition to get special leave. Those are all costs involved. From there, it's got to go to the Supreme Court of Appeal, and then, of course, once, you know, if there's an arguable point of law, it can go then to Braamfontein. And 12, 13, 15 years later, a bit too late, like Ms. Grootboom, it was too late to help her. These are the difficulties that we face. So, I think we're a young democracy and we're learning. And it's not that we failed, it's that we're learning and we're making things better. So we learn as we go along what's the best way forward and what suits this young democracy.
Thank you, Judge.
Thank you.
If I may do follow
Thank
up,
you very much.
CJ.
Thank you, Judge Carelse. We still have colleagues. We have 10 more candidates to contend with. And if
Chief
yesterday's
Justice
experience
Sorry, Mr. Siko. Mr. Sikok, I forgot to mention that I trained your attorneys too, all the way in Mpumalanga.
CJ, if I may make a follow-up on the issue of streamlining of the appeal process.
Yes, I was still just completing a point. You'll
Okay, thank you, CJ.
That we still have 10 more candidates to go. And if yesterday's experience be anything to go by, it looks like we will have to go into the early hours of the morning this time around, because we had fewer candidates yesterday. I thought I had to caution all of us, including myself, including President Maya, and all the commissioners about contributing towards shortening the proceedings without compromising the quality of the interviews. Over to you, Commissioner Sigogo.
Thank you, CJ. Good afternoon, Judge.
Good afternoon. Well, thank you.
Thank you. You agreed with the CJ that it could be important that the appeal process be streamlined. But when thinking, you indicated there was one of your judgment where one part was overturned by the Supreme Court of Appeal, and then it went to the Concord, then it was again confirmed. If the two courts were made one, we're going to lose that particular aspect, and the litigant would have lost the benefit of the reconfirmation of your judgment by the Concord. Don't you think so?
Mr. Sikoka, I get where you're coming from, but yeah, I don't, I sort of bragged when I said that, but I think if we have a one appeal court, I'd be satisfied because I'd have confidence in the judiciary. And if my matter ended at the Supreme Court of Appeal, I would have to accept it because that's what we do. Every day we deliver judgments and we're overturned. So I think it has to be thought out. It's not something you can wake up one morning and put it into place. I think it's a lot of thought, but at the same time, you have to balance the difficulties with, access to justice, litigants, the cost involved to your matter. So yeah, I don't know what the easy solution is, but I think maybe, I think one appeal court might work.
So once more, last time, but it's not about the judges, but about the litigants. It is that litigant who got justice at the end of the day. Don't you think it was necessary for that litigant?
Of course, it's always about the litigant, Mr. Sikoko. Before the amendment, litigants were satisfied because matters ended in Bloemfontein. And then the jurisdiction was extended and then it went there. So it was the final arbiter in many cases. But as I say to you, it's been out in the public and it's a concern about the process. And, the CJ is there. He knows the difficulties trying to finalize, the amount of work that comes through. But I don't know but that might be one solution. Whether it's the right solution, I'm not sure. But yeah, I think we must give it more thought and maybe consult with the professions to see the best way forward.
Thank you, CJ.
Okay.
Thank you, Judge.
Thank you.
CJ,
Thank
sorry.
you, Commissioner Sigogo.
Could you indulge me, CJ, please?
Is that you, JP?
Yes, please, CJ. I just want to clarify certain facts. It won't take 2 minutes.
Sure.
Go ahead.
It will have a bearing on the interviews when the division brings candidates here.
Yes.
Go ahead, JP.
Thank you. Judge Carelse, just confirm or clarify if me and yourself had a discussion about the DJP position.
Yes, we did.
Am I correct that it was your preference that you'd rather write judgments? You want to go to the SCA?
No, we had that discussion.
Thank you. And at the time we had that discussion, is it correct that at that time, in fact, the whole of last year, you're the only woman in the top 10 in the division?
That's right.
Is it also correct that most women were appointed mostly from 2011, 2012
That's right.
onwards? Before then, only men were being appointed in that division.
That's for sure. Yeah.
Thank you very much, Chief Justice.
Thank you, JP. Thank you very much for coming, Judge Carelse. You're excused.
Thank you, commissioners.